Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is How Clean Are Your Claims? Understanding the new Anti-Greenwashing Amendments to Canada's Competition Act. As of June 2024, the Fall Economic Statement Implementation Act brought significant changes to Canada's Competition Act. Among the changes were new provisions targeting so-called greenwashing, or misleading claims in product advertising regarding environmental benefits. In a reversal of previous law, the amendments place the burden of proving that environmental benefit claims are based on adequate and proper testing or substantiation on the party making the claims. What's more, they now enable private parties to bring cases for deceptive advertising practices directly before the Competition Tribunal. In a related development, the Competition Bureau subsequently issued proposed guidelines concerning environmental claims. In today's episode, we'll be talking to an experienced Canadian consumer protection lawyer about the greenwashing amendments to the Competition Act, the guidelines, and how companies can make sure that their public-facing environmental claims and commitments comply with the new law. But before we talk about that, I'd like to welcome my co-host, Anora Wang. Hi, Anora.
Hi, Alicia.
Would you like to introduce our guest and kick off the conversation?
For sure. Our guest today, Candice Kloes, is a lawyer in the Toronto office of Borden, Ladner, Gervais, also known as BLG, the law firm, where her practice focuses on advertising, consumer protection, and regulatory law. Candice has counseled clients on issues including product labeling, advertising and marketing campaigns, influencer marketing, greenwashing, and advertising to children. And she is a member of the Ad Standards Canada Council. Welcome to our program, Candice.
Thank you so much. Thank you for having me.
So to start our conversation, let's understand the new greenwashing amendments to the Competition Act. What are the key changes concerning the regulation of advertising environmental benefits? And what essentially are the amendments intended to accomplish?
Well, I wanted to start by saying that the Competition Act is largely an antitrust piece of legislation, but one of the main purposes of the Act is to protect the consumers from deceptive marketing practices. The new amendments help ensure that consumers can trust the claims that advertisers make, in particular environmental benefits claims, and to make sure that they are based on accurate information rather than just creating marketing hype. More specifically, the new greenwashing provisions codify that environmental benefits claims that are not based on adequate and proper testing are false and misleading.
So one of the most notable changes, as you highlighted and we previewed, is that the law is shifting the burden of proving that an environmental claim is properly substantiated to the party making the claim, essentially who is putting the label, who is writing the label, right? Previously, the challenger has the burden of proving, say, like I'm a consumer, I'm not so sure about what's claimed. I would be the one having the burden to prove that a claim was false or not properly substantiated. So can you tell us a bit more about the kind of proof that a party would need to submit to avoid liability now under the new law?
Sure. As you mentioned previously under the law, the Bureau or anybody challenging a claim would have to really allege and prove that a claim was false and misleading. The new provisions actually change that by making it mandatory for advertisers to have substantiation before the claim is made. And that's really where the reverse onus comes into play. There are two new provisions under the Act, and the one deals with products, environmental benefits claims relating to products, and that should be based on adequate and proper testing. Now, under Canadian law and case law, this is something that's been tested, and so this is pretty clear what that means. The other new provision, and which has really created a lot of uncertainty under the new provisions, is environmental benefits claims relating to a business or a business activity. And that needs to be based on adequate and proper substantiation in accordance with internationally recognized methodology. Now, not only is that a mouthful, but really nobody actually knows what that means. And really, essentially, apart from what they really mean, but in terms of the reverse onus, now it kind of makes a presumption that if an advertiser has not based their claims on adequate and proper testing and substantiation at the time the claims were made, there's a presumption that those claims are false and misleading. So really, it makes it significantly easier for the Competition Bureau, who is the federal law enforcement agency who administers and enforces the Competition Act, to take action against advertisers.
What can you tell us about the guidelines that the Competition Bureau have been working on? Are they supporting this legislation in a way that you think will be helpful or just raise more questions?
For the most part, the guidelines that the Competition Bureau has issued is very helpful. We need to remember that the guidelines are not law, but they do bring welcome clarity and a lot of uncertainties under the new provisions. Very importantly, it clarifies the Competition Bureau's enforcement approach. They won't be enforcing the new provisions retroactively. So any claims that were made before the Act was changed, they won't bring claims under the new provisions. Another important point of clarification that the guidelines bring is that the Bureau will not challenge voluntary or mandatory disclosures made by investors, on condition that these disclosures are not made in marketing materials. So this was helpful clarity as clients were asking for this. Another big question that our international clients, particularly in the US, were asking is whether the new law applies to them. The Bureau says yes. As long as you are touching the Canadian consumers, or if your marketing campaigns are focused on the consumers, the law will apply to you. The Bureau had a very difficult task of clarifying what internationally recognized methodology means in the sense of substantiating an environmental benefits claim as to a business or a business activity. The Bureau says that this can stem from a variety of sources, including standards set by bodies, regulatory bodies, or authorities, or industries. And if no single internationally recognized methodology exists, advertisers may rely on a combination of two or more. I don't think that that's necessarily helpful, and I think time will tell as to how the courts and the Competition Tribunal will interpret this. And as I said, these guidelines are not law. So it remains to be seen whether the courts or a tribunal will actually agree with the Bureau's position on a lot of these points.
The guidelines and the law would touch different industries, and then some industry may be impacted more than others. Could you tell us whether, in your view, some industries have been impacted more or more closely or to a greater extent, and do the provisions already have that impact?
So I think you won't be surprised to hear that the oil and gas industry in Canada has really been concerned about these new provisions. You've seen some companies wiping down their websites completely of any environmental benefits claims. So that's definitely been something that we've seen in terms of trends. Essentially, though, these new provisions apply to everybody and in every industry. We've seen enforcement action from the Bureau against big retailers, big clothing manufacturers. So it's not just to say it's the oil and gas industry, but really it is everybody.
Either in connection with the amendments themselves or the guidelines, what have been some of the biggest criticisms of the new provisions?
The main one is the vagueness of the new provision for business and business activity, and that's the test for in accordance with internationally recognized methodologies. It really leaves a lot of confusion, and companies aren't sure how to actually substantiate their claims and on what basis. And if there are more than one internationally recognized methodologies, how would one harmonize it? So that's definitely something that we've seen, and it's been difficult to grapple with. Also, what we've seen and what companies are very concerned about is the risk of over-enforcement of these new provisions. Similar to the US, environmental activists are very concerned about what companies are doing and saying in Canada. Before the new provisions, there were a lot of complaints to the Competition Bureau. And so with these new provisions being a lot more broader, more vague, it really just opens up a lot more risk of enforcement and over-enforcement in Canada.
I do have a question, kind of follow-up. Are these provisions and new laws and regulations applicable to goods sold in Canada as well as Canadian-made goods, perhaps sold to the U.S.?
That's a good question. If goods are manufactured in Canada and they're destined for the US, the laws in the US will largely apply. But if there is a consumer-focused campaign to consumers in Canada somewhere throughout that process, and this is where the online marketing is really dangerous, because it's sometimes very difficult to demarcate who actually sees the advertisements. Yeah, I think that's the answer. I think at the end of the day, if a consumer can see it, can purchase it, if it's available to consumers in Canada, the new law will apply, even though the goods are destined for sale in the US.
Another important change that you have highlighted and we have alluded to already is that authorization of private rights of action. So meaning individuals like you and me, perhaps more you than me as a Canadian consumer, can challenge environmental claims directly before the competition tribunal. What exactly does that mean? And what, in practice, what effect has that brought already?
So this has been a big concern for advertisers in Canada, and this private right of action is not only available for misleading marketing claims, it's also available for antitrust claims, generally under the Competition Act. As of June this year, it's been opened for deceptive marketing practices. So that means that private parties, including environmental activists, no longer need to rely on the Bureau to take action for their concerns. Private parties can go directly to the tribunal and apply for orders. However, they need to seek leave from the tribunal before doing so. And the threshold there is it must be in the public interest to do so. The Bureau has also issued its guidelines on the new private right of action, and there are a number of steps that need to be taken before the tribunal can actually hear these matters. So in addition to the requirement of it being in the public interest, private parties have to serve their complaints on the Bureau. The Bureau will then assess, okay, are they already, taking action against a company? Can they intervene? So there's a lot of steps that the Bureau can actually do to step in and take over. So I'm not necessarily expecting a floodgate of cases at this stage. It remains to be seen, because I also expect that if the public interest threshold is met, the Bureau is going to want to step in. So it's going to be interesting to see how this plays out and which cases actually get through to the tribunal through private parties.
So have you seen any indication of new cases being brought?
To my knowledge, there have not been any cases under the new greenwashing provisions. I believe there have been a few cases under some other provisions of the Act, perhaps the general deceptive marketing provisions, but nothing in the greenwashing space as yet.
One thing I'm curious about, Candice, is how much is greenwashing regulated at the provincial level? Has this always been something of concern at the federal level? Are you looking at what might now be a patchwork of regulation, kind of like what we have here in the United States with respect to a lot of issues in the consumer protection field?
For the most part, the consumer protection laws and the Competition Act are aligned when it comes to deceptive marketing and misleading advertising practices. Similar to the Competition Act, the consumer protection laws on a provincial level have provisions prohibiting unfair practices, including misleading advertising practices. So we have in the past seen many class actions, a lot of complaints under the provincial laws. The test for a misleading advertising claim is very similar under the provincial laws and the Competition Act. There's some nuances. A recent case law has clarified that, but really it is from the point of view of the credulous and inexperienced consumer, right? Somebody who is very easily misled. And it's the general impression test that needs to be applied under both pieces of law. And that's really aligned across the board. I don't expect that there's going to be any patchwork going forward. I don't see that provincial governments will be changing laws to follow up on the federal laws. I don't think that the provincial laws are necessarily more restrictive. They definitely are aligned, and in the class actions that you'll see, there's a number of them going on in the greenwashing space. Consumers often claim under both acts, under one class action. So, for example, they'll claim damages or whatnot under the provincial laws, but under the Competition Act, there's also a right to claim for damages for misleading advertising claims.
Well, it sounds a little bit less messy than sometimes what we
Certainly.
have to deal with here. Another question we had has to do with the Canadian government's so-called greening government strategy and the zero plastic waste agenda. How does that intersect with what's going on with the greenwashing amendments to the Competition Act?
So to take a step back, the Canada's Zero Plastic Waste Agenda is really a comprehensive, multi-phase initiative that's aimed at eliminating plastic pollution by 2030. There are a number of initiatives under play. There are a few regulations that have come about that are in the works, really, and it takes a lot of collaboration on a provincial and federal government level. Most notably, in June 2022, there was a single plastic waste ban. So Canada prohibits the manufacture, import, or sale of different single-use plastics, such as plastic bags, shopping bags, cutlery, food serviceware, etc. One of the legal reforms under the agenda that more closely aligns with the amendments to the Competition Act are the new labelling regulations. So in April 2023, the federal government published new regulations aimed at recyclability claims and compostability claims. What these encompassed was to mandate minimum levels of recycled post-consumer plastics in packaging. There's recyclability labeling rules and compostability rules. The new labeling regulations were meant to be published in the Gazette at the end of 2023. At this stage, we're not sure why they haven't been published yet. We can only speculate. Perhaps one of the reasons is because the regulations, the single-use plastic regulations that I mentioned earlier, those are currently being challenged in court. Amongst other things, it's being challenged on the basis that the federal government does not have the power to regulate environmental issues. So it could be that the government's waiting for the outcome of that court challenge. And also, Canada is actively involved in the negotiation for the proposed global UN plastics treaty. And so they're probably waiting for the outcome of that before making any significant changes under the law.
Sounds like many things are happening at the consumer protection front in Canada. You're becoming cleaner. The manufacturers are forced to make claims that's substantiated, and you're not using single-use plastic bags. It's making it all or more of a wonderful country to visit. Anything else we need to know about consumer protection enforcement in Canada at the moment?
So apart from the new greenwashing provisions, the Competition Act was also bolstered to target drip pricing, so junk fees. That's been a very active point of enforcement from the Competition Bureau. There was a big court case last year on the basis of drip pricing, and the Bureau is actively going after big companies on this. The Bureau has also released its annual strategy, and online marketing, fake reviews, impersonations, those sort of things are really a big focus of theirs going forward. So I think in the world of consumer marketing, online marketing, I suppose very similar to the US, is something that the Bureau as well as consumers are paying attention to.
Well, thank you so much for bringing us up to date. For listeners who want to hear a little bit more about the topic of today's episode, we're posting on the episode webpage 2 articles that Candice wrote with her colleagues very recently covering these changes and the guidelines that we've been talking about. So please check out that episode webpage. Now, before we let you go, Candice, we're going to do a couple of things we like to do with every guest to get to know you a little bit better as a person. And the first question we'd like to ask is there anything interesting or unusual about yourself that is completely outside of your professional life?
I think, as you can tell by the accent, I'm not originally from Canada. I'm a fairly new Canadian, and I've lived and worked all over the world, starting in South Africa, but I also spent almost 10 years in the Middle East, in Dubai, which was wonderful. So I truly am an international lawyer, and have worked in-house, private practice. I know I'm not supposed to talk about the professional stuff, but yes, I think that's really something that's a little unusual.
Okay. The next thing we're going to do with you, Candice, is to play a little game we call The Curious Hat.
And now it's time for the Curious Hat!
The rules of the game are extremely simple. I'll ask Anora to pull a random surprise question out of the virtual hat. Take it away, Anora.
So the question for you is, do you like to dance? And if so, how would you describe your dance style?
I do. I don't dance very well. I like to go back to my African roots, and I really like to, let it all out at home with my kids in the typical, I'm a piano kind of way that you would see some of the very famous people from South Africa doing. And we don't hold back.
So you're dancing like nobody's watching, right?
Exactly.
Oh, very good. Well, thank you so much, Candice. This was very interesting and informative. Thank you, Anora, for being a fabulous co-host, as always. And thank you, listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.